was almost embarrassing watching the initial reports to that trooper. She was hyperventilating, hysterical. He's having to teach her box breathing, giving her a hug, all the things. And it's comical as she's like, yeah, hey, can you get the box full of incriminating evidence out of my car? It's all nicely packaged up in a red tote for you. It's sitting right next to my son. And at no point during any of this did anyone question whether she might have been involved in it instead of just reporting it. She claimed that she had been held captive by my client for 2 days, her and her son. Either way, if you're being held hostage and you're not in the house with the guy who's holding you hostage,
how are you a hostage?
held hostage.
That's so truth.
After they searched the hotel room, he had been given permission to go back to the hotel room. And as soon as she went back to the hotel room, she reached out to law enforcement and said, I've got this bloody glove. And I've got this jacket of his that has these 5 spent shell casings in it, in the pocket. And I'm going, they're unpacking these suitcases looking for evidence, and you think they're not going to hear jingling shell casings? And we're talking about narcotics officers. I mean, they're used to looking for any tiny little babies.
That's right.
So you think if there was a hand-sized red baseball glove covered in blood, they're probably not going to miss that.
I would say they're not going to miss that.
I mean, the detective was like, if we miss that, I've been doing this for a long time. I have questions. If there was a possibility of her being able to tell a lie, she opted to tell the lie, even if it didn't matter or help her. And we discovered that not only in the interview, but absolutely on the stand.
I'm listening to you and I'm thinking I would love to be cross-examining this lady.
It was fun. Very fun. There's another lie. I asked her how many children she had. She said 2. And I went, really? She said, yeah, I have 2. I was like, oh, you mean this one and this one aren't yours? You don't have 4? And she's like, oh, why would you bring about how many kids you had? How does that move this forward?
In this episode, we delve into a capital murder case where our guest, Brittany Lannen, took over as lead counsel just days before trial. She had 2.5 days to prepare a case involving 31 witnesses and a 2 terabyte thumb drive of cell phone data. And for those of you who don't know, 2 terabytes is 2,000 gigabytes. The allegations involved multiple murders in one occurrence, specifically the murder of the client's sister's fiancé and his mother, who all lived together. A key focus of the defense was the lack of investigation into the sister, who hysterically made the initial complaint and suspiciously magically located crucial evidence. Brittany will share how she navigated this challenge, including cooperation from the prosecutors, which is good and what we should have in all our cases. And she had a lot of help from her client, who was a very intelligent individual. So, before we get into the case, let's get to know Brittany. So, Brittany, tell us a little bit about yourself and what inspired you to become a criminal defense lawyer.
Well, I grew up here in Texas, and I grew up in what I would call a Cinderella town. We didn't have much in the way of crime. Bad things didn't happen. It was every parent's dream. But my dad was a police officer, and so he knew the realities of the world. My mom worked in a polygraph examiner's office, so they wanted to make sure that I had some exposure to the real world and the bad aspects of it, so I could be appropriately safeguarding myself when I got to college and when I went into adulthood. So my dad used to have me edit polygraph exams that he did on the side. And then they had me read a book called Obsession by John Douglas and Mark Olshaker. It is a book about FBI profiling and specifically looking at rapists, murderers, etc., and how they investigated those cases. It was a very eye-opening experience. And the injustice that I felt in reading that book and the things that happened to the victims in that book really made me want to pursue a career that helped those victims. So I did not start off on the defense side. I actually started off on the prosecution side. A lot of people do that. So you get a very quick taste of trial work. And then within about 4 years, I ended up starting on my own. My mom ended up being an entrepreneur. Her whole side of the family is an entrepreneurial side of the family. So I caught the bug as well and decided I really wanted to do some defense work myself and start my own business.
What city and state do you currently practice in?
So I am in a smaller town about 30 minutes outside of Waco, Texas.
And your practice covers what part of Texas? Not just Waco, I would imagine. And certainly not just a small town, because I grew up in a small town with 2,000 people, and there's not a lot of work just coming from there.
No, there's not. So I cover Waco and then essentially all of the surrounding counties. I've had cases that took me down to counties that border Mexico. So if it pays and I've got a reason to go, then I'll certainly take that case as well. But for the most part, most of Central Texas is something that I will handle.
What's a typical day like in your practice?
In my practice, I do a lot of court hearings and whatnot, or I'm drafting a lot. But my practice has morphed to include a lot of family law cases. I definitely wanted to pursue cases that involved children and ensuring that they were being served by the justice system as a whole. So as a prosecutor, I was a child abuse prosecutor. And now as a private practitioner, I do a lot of CPS cases and family law cases, but I will always, first and foremost, be a defense attorney.
As a criminal defense attorney, what would you say is one thing people often misunderstand about what you do?
A lot of people think that I believe in my clients' factual pieces versus being a test for the system. My job is to be a test for the system. I serve the public and society by being a test for the system and ensuring its integrity.
Yeah, I tell people all the time, one misconception about criminal defense lawyers is that we think nobody should go to prison. And I don't know anybody that does criminal defense that believes that.
I don't either.
We're essentially there to maintain the integrity of the system as a whole. Routinely, we have clients who should go to prison, but we're there to serve as really a balancing test. If this man or woman should go to prison for what they've done, what's a fair sentence? And we can't just have one side deciding.
Certainly. I mean, it is my biggest fear to have an innocent person, obviously, go to prison. But at the same time, it is important to me to make sure that if a guilty man has to go free because it protects the system and ensures that law enforcement, prosecutors, and everybody involved from the beginning to the end has done their job to the best of their abilities and by the law, then so be it.
What would you say sets you apart in criminal defense? Because I know there's a lot of attorneys and everywhere we go and practice, Waco included. So if somebody was looking for a criminal defense lawyer in that general geographic area that you cover, why should they call you?
My office distinguishes itself from others because, A, we have a remarkable relationship with our investigators. There are hardly any cases that I take on that I do not incorporate my investigators in some form or fashion. We look for more than just the surface level information in order to establish what happened in a case, in order to ensure that we can't, frankly, develop reasonable doubt on our own that maybe we wouldn't have thought of had we not done some more investigation and research. And I unfortunately have some personal experience of being a victim of data theft and fraudulent identification theft. If researching and investigating that on my own, I became a better attorney. I realized how I could document things and source events and document how those events took place and who was doing them when it might have looked on the surface to be me, when it was in reality an employee of mine.
We might go into that certainly in this case. Let's dive into the case that we're here to talk about. Can you give us an overview of what the case was about, your client, and how you became involved?
I guess the best way is to say the prosecution's theory was that my client and his sister lived together with his sister's fiance and his sister's fiance's mother. I know that's a lot. And at some point, there was an altercation between my client and the fiance, and that altercation led to my client firing a weapon towards the fiance and killing him. And then in turn, I guess callously saying, hey, we don't need a witness to anything, and killing the fiance's mother as well. And then the prosecution learned of this case was because his sister reported to law enforcement that right after the killing, they stayed in a couple of different hotels, actually, for 2 or 3 days. And he was holding her and her son hostage before she was able to free herself and report to law enforcement.
It's a lot.
It is. It sounds very damning.
If we just run with that, your guy goes to prison for the remainder of his life, right?
That's true. This was a mini cap, is what we call it. Life without parole is the only option if he was found guilty.
Let's get to your first meeting with your client. Tell us how that goes.
This was a career first, for sure. The first time that I laid eyes on or spoke to my client was roughly an hour before jury selection. So I approached him in the courthouse in one of the side rooms that they have for the attorneys to talk to their clients who are in custody, and introduced myself for the first time. And I was prepared to, and had filed actually at his request, a motion to substitute in the standby counsel, which in Texas, that means that he's representing himself and he sits at counsel table himself. And then I sit behind him without a desk or anything. I'm just sitting in the row of chairs behind him. And I'm there as a living, breathing law library.
So 1 hour before jury selection, that was supposed to be your intended role, right?
That was supposed to be my intended role.
Okay, so tell us what happened.
Shortly after the judge agreed that I could substitute in as counsel, because according to the judge and the law, my client has the right to choose who his counsel is if he's retaining them in particular, if they're not court appointed. And so he chose me. So judge allowed this and acknowledged that he was not inclined to grant any kind of continuance just because of this event. We understood that was going to happen. And we had a little bit of time to prepare before jury selection began. So when we talked before jury selection began, my client mentioned that he would kind of like to just sit back and let me take over and handle everything.
Okay, now you say, because I got to give people some context here. You say we had a little bit of time to prepare before jury selection. And I can give an example. If I have a trial starting on a Monday, I'm typically working on my jury selection and refining it the week prior to jury selection and certainly over the weekend. Now, when you say a little bit of time to prepare, what does that really mean?
20 minutes? And at this point, we're telling him, please don't. My investigator is there. I'm there. And you said in the beginning that this was a success due to the cooperation of the prosecution and my work and my client's intelligence. I will tell you, the key to our success was my investigator. She was there. She is the reason I was involved in the first place. And we're telling him, hey, judge is not going to have me sub in now as lead counsel. This is you, buddy. Go ahead. You wanted this. You've asked for it. We're going forward with you. We go out into the courtroom with the prosecution there. We're getting ready. Judge asks, is everybody ready? And the client turns around and says, Judge, I think I would like to step back and let her be lead counsel. And I fell to the floor because now I'm looking at a room full of attorneys who we all share the same bar card responsibilities and obligations and standards. So I assure you, every one of them had that thought of, is she going to expose herself to malpractice here? I mean, who would actually agree to do this?
That takes a lot of courage.
I think I have come across a lot of hurdles in my past for the sole purpose of preparing me to be able to help people like this.
I gotta ask though, for a guy facing a mandatory life without parole in a double homicide case to turn everything over to a lawyer who he's only met within the last hour or so, there's something about you that must have made him feel comfortable. What am I missing? What made him choose you in such a limited amount of time of knowing you for such a massive role?
My investigator had received a call from the judge directly. He had gone through several other investigators and the client was just not cooperating. It was upset. He was having problems at the jail. So as a last effort, judge called my investigator and asked her if she would be willing to come in and work with him. And she agreed. So she started working with him. And as she would come across questions, because she hadn't worked with a pro se individual before, she would reach out to me and ask me about them. So to say that I had never seen anything about the case before is a little off. I was familiar with the general facts, but she had done wonders with him. He stopped causing any problems at the jail. He was truly invested and focused on his preparation for his case. And she was consistently referencing my name. And so he trusted her and had so much faith in her that when she said, I need Brittany's help, I think you should ask her to sub in as standby counsel, he was 100% convinced. So I truly credit her, all the work she did to develop a rapport with him.
Is that the investigator that you work with all the time or quite often?
Yes, we've worked together almost exclusively for roughly 10 years.
Okay, so that's great. Your investigator knows what you expect and
Yeah.
vice versa.
We work very, very well together after that much time. We don't even have to say all of the things anymore. We know what to expect from each other.
So let's go back to the incident itself. I want you to kind of give us a play-by-play breakdown of the incident as you believe it occurred, as well as the subsequent investigation that led to your client ultimately being charged. And then after we do that, I kind of want to go through the trial and see how you dealt with it.
How I believe it occurred. I believe that my client had observed his sister. I'm going to use names just because it starts getting a little confusing. Sister's name is Christy, and then her fiance's name was Michael. Middle name is Angelo. Last name is David. So they call him David. His mom's name is Gina. Christy and David fought quite a bit. And apparently it was a little bit manipulative whenever they would start fighting. They kind of had the same actions each time. He would take her car, or he would move money from the account. He's done that once, I think, maybe twice. It was not a healthy dynamic. Their fighting was not an example of healthy fighting or healthy conflict resolution. So they had been fighting the entire day, as we understand it. And Christy's son was there. So my client's nephew was there as well. My client is not a fan of kiddos seeing altercations and fighting like that. I will say I'm very confident in that value of his, that he does not want the kids to be harmed or be around that kind of thing. So he, at some point, lost his tolerance of observing the fighting, and believed that he actually had David drive him to and we stay at TGI Fridays for several hours watching the football game that day, having a couple of drinks. Intoxication was not an issue in this case, so it really was just a couple of drinks and dinner. And ultimately, his card wasn't working, and he messaged Christy, his sister, and said, hey, my card's not working. Can you either come get me, or can you give me a ride home? Can you schedule a ride for me with Uber? She didn't want to leave the house at that point, so she did schedule an Uber, and that Uber picked him up and brought him home. And that's when things get a little bit difficult documentation-wise for us. We couldn't document exactly when he got home, but the timeline worked so closely that we have other evidence from the cell phone dumps that showed the last text, and the timeline of my client arriving at the house had to be within just minutes of each other. So our perspective is my client walked in and was told by Christy, standing at the front door, right next to the stairs at the front door, is what he would say, that she just shot him. And my client is a man of many words. He's very quiet, very stoic person. He said, I went into business mode. Okay, this is the status. This is where we are. This is the next step. We got to do something about it. And at some point in this communication, it is confirmed that Gina had also been shot, but my client never went in that room or saw her or anything. The two promptly got the nephew and the residence and went straight over to a hotel. The next day, by all accounts, everybody agreed. They went back to the house. Christy would say that he went inside and he did all of the cleanup all by himself. Moved the bodies, bleached everything, shampooed the carpet, or that's not what happened. She was very actively present in that situation and was in one room cleaning while he was in the other room cleaning. They did relocate the bodies into a vehicle in the garage. And then my client's not from here. He'd only been in Texas for about 6 weeks. He had no idea at that point, where are we going? What are we doing? And Christy didn't really either, but she wasn't as concerned about it. She was more concerned about literally going shopping. So they went shopping and they got her a new car so she could get a bigger car to put more of her stuff in it from the house, because she wasn't going to stay in Texas at this point. She was going to go back to California where they were from.
Wow.
Yes. I mean, talk about a callous response. They shopped and whatnot that day. And then the next day, I believe they were scheduled to pack up and leave and go. I think they changed their plans and they were going to go first to Arkansas, where some family members lived, and then drop off my client. And then she was going to proceed on to California. At some point, they deviated, or she decided to deviate from this plan. And she tells my client that she's going to the vending machines. And instead, she has gone and gotten in the car and left. I mean, completely bailed. That's when he gets a little concerned. What are you doing? Why would you tell me you're going to the vending machines and then leave? And she's not the most trustworthy individual. I mean, he's his sister. He knows her. So he thought, uh-oh, something's about to happen. I think she is about to pin all of this on me, and she's going to try and get away with it. Essentially, that's exactly what she did. She had reported to law enforcement. She actually flagged down, I think he may have already been parked, but stopped and pulled over next to a trooper. And it was almost embarrassing watching the initial report to that trooper. She was hyperventilating, hysterical. He's having to teach her box breathing, giving her a hug, all the things. And it's comical as she's like, sure, I'll follow you to a secure location at a different, police agency's office. Yeah. Hey, can you get the box full of incriminating evidence out of my car? It's all nicely packaged up in a red tote for you. It's sitting right next to my son. Okay. So that, and then apparently there was, if you got into the trunk, there was a huge duffel bag full of firearms.
Wow. Where are the bodies? What do you do with the bodies at this point?
They're still in the car in the garage in Texas in September. Well, early October.
I know that's like.
Yeah, it's rough. She made her report. This is where we have concerns about law enforcement's action. Law enforcement had people that went out to the house. They didn't make initial contact. They got some more clarifying information. Hey, we're alleging deceased bodies. You can go in. And they ended up making entry into the home. But before they ever made entry into the home and found the bodies, they already had my client in handcuffs. And he never got out of custody that day. They hadn't even confirmed that a real person, was harmed. They just had a singular statement by a hysterical woman. That's it. And in custody. That was very concerning. He didn't participate in any kind of interview or anything like that. He did want an attorney. And he proceeded to interview for several hours. And at no point during any of this did anyone question whether she might have been involved in it instead of just reporting it. She claimed that she had been held captive by my client for 2 days, her and her son.
Oh, was the son?
He was 7 at the time.
So he was old enough to know if he was.
Yeah. She interfered over the next couple of days. She interfered very obviously in their ability to interview the son or do a forensic with the son. He refused to even go into the interview room. And she was very visibly in front of him, objecting to the idea that he should be interviewed. So of course he's going to refuse. Within moments of being kind of done with that first phase of the investigation with law enforcement, she is on the road and halfway to California.
Getting out of there, booking it out of town.
Ultimately, law enforcement went and had searched the residence, of course. They did find the bodies, and then they proceeded to search the entire residence, including the garage where the bodies were located. They also searched the third hotel. This was now hotel number 1 on one night, 2 on 2 night, and then 3 on the third night. And they searched the hotel. And we're talking about narcotics officers. I mean, they're used to looking for tiny little babies.
That's right.
So you think if there was a hand-sized red baseball glove covered in blood, they're probably not going to miss that.
I would say they're not going to miss that.
I mean, the detective was like, if we miss that, I've been doing this for a long time. I have questions. After they searched the hotel room, she had been given permission to go back to the hotel room. And as soon as she went back to the hotel room, she reached out to law enforcement and said, I've got this bloody glove. And I've got this jacket of his that has these 5 spent shell casings in it, in the pocket. And I'm going, they're unpacking these suitcases looking for evidence. And you think they're not going to hear jingling shell casings? They're unpacking duffel bags that only have my client's clothing. All her stuff stayed in the car. She instructed him to unpack all of his bags so they could reorganize them and make more room in them to carry more stuff. And they're unpacking all of that and somehow missed these jingling shell casings in the jacket pocket.
Yes, I don't think so either.
That was a huge problem. There were various points during her interviews where her story was inconsistent, like why she wouldn't go get him from TGI Fridays, little things that she didn't have to lie about. But man, if there was a possibility of her being able to tell a lie, she opted to tell the lie, even if it didn't matter or help her. And we discovered that not only in the interview, but absolutely on the stand.
I'm listening to you and I'm thinking I would love to be cross-examining this lady.
It was fun. Very fun.
Did she not get charged at all?
He was never charged. In the records that we saw, there was nothing suggesting that they seriously looked at her as a suspect. They say that there were some conversations about it, but there's nothing documented where they seriously looked at her as a suspect.
At a minimum, you would think if a murder occurs and she helps with the cleanup, at a minimum, that's obstruction of justice.
At the conclusion of their investigation, they didn't believe that she had helped. So they thought it was entirely my client and that she just wasn't there or was sitting out front. I'm not sure. I can't remember what her story was. Either way, if you're being held hostage and you're not in the house with the guy who's holding you hostage.
How are you a hostage?
Being held hostage.
That's so true.
And considering the text messages between them where she was actively text messaging things that confirmed that she was not with him at times. Hey, the pizza guy is going to be there in 20 minutes and you pay for it if I'm not back yet. I'm not there. So why aren't you just running off to law enforcement then? Well, she claims that he had people following her. He told her that he had people following her. He'd only been in Texas for 6 weeks. He didn't know anybody down here. And even if he did, how did you know somebody so confidently in 6 weeks that they'd be willing to tail your sister for you on a whim?
Yeah, that's absurd. So all of this has to be taken into account in your 2.5 days that you have to really prepare for the trial.
That would be a generous timeline. So we picked our jury Monday afternoon and Tuesday. And then we were able to come back. We were supposed to start testimony on Wednesday morning. When we got to court on Wednesday morning, we explained to the court that we had spent all of Tuesday afternoon with the prosecutor's office updating software, changing things on my computer to ensure that I could open the cell phone dumps and ultimately could not open them. And so we ended up having to go and buy a 2 terabyte drive, bring it back to the DA's office. They dumped everything onto the terabyte drives, and I didn't get those until Thursday after the first full day of testimony.
Oh, wow.
So I really only had a day and a half, and then we had testimony, and then I got the 2 terabyte drive.
I would not have wanted to be in your shoes.
It was a lot of late nights and a lot of coffee.
So let's start with jury selection. Now that we have a good idea of what the facts were, what was your theory of defense and how did you cover that during jury selection?
I had an idea about the general defense theories or points that should be made if you were representing himself at the time. So I did kind of your basic defense for dire, like, hey guys, who's going to be the annoying person in the courtroom this week? That would be me. I'm going to be standing up. I'm going to be stopping the testimony and objecting to things. Why am I doing it? And we explained a little bit about, my dad's a police officer. My husband is a police officer. So I don't hate police officers at all. I am just ensuring that police officers are the good guys that we want them to be. And if they've made a mistake in this one, okay. It's just a mistake. That's fine. If they did something intentional, okay. Either way, we have to make sure that my client isn't harmed by a mistake or an intentional act. And that's my whole job in keeping the system safe for everybody. Thankfully, there was a recent case where in McLennan County, so just one county away, where the sheriff's office there had extradited somebody from, I believe it was Utah, and had zero connection to the case. Somebody just missed a Snapchat name, one of those made up, a handle or whatever they call it, on a sticky note. They misread it. That's how this individual was tied to a case and then arrested and extradited, ruined his life. So we went through that example, became much easier, I think, for a lot of people to go, oh, okay, it might actually just be the wrong guy. So I hate that for him, but it really made our job as defense attorneys much more understandable for a lot of jurors. So we talked about that. We also talked about the burdens of proof and whose job is what. And then we talked a whole lot about if there is if there is the possibility or the ability to easily get evidence to law enforcement, and they choose not to, what are we going to do with that? And should I spend some time highlighting that and explaining that? And the reason that we did that was because they had all of these cell phones, and cell phones are a treasure trove of information. I mean, they tell you so much about anybody that is holding one. Even if that person doesn't know how to use it very well, it still says a ton about that person. And they never once did the cell phone dumps. Not until I think the first one was done in August, and this trial was held August of 2025, mind you. The offense occurred in September, October of 2020.
Oh, 5 years.
For 5 years. To the day. We picked the jury on the day they alleged that the murders occurred 5 years later. Yeah, which made it a little bit easier also to talk about. And I did talk about in the vote higher. We're going to be pretty open in other crimes that might have been committed here. Tampering with a corpse is a crime. Guess when the statute ran, because they could not prosecute that the day of jury selection. We knew that was going to be fair game, and we were going to talk all about it and not hide it one bit.
That's maintaining credibility in the courtroom. I tell people there's many trials we have as criminal defense lawyers where we just have to own up to some things our clients have done. Otherwise, you risk losing all credibility, which is not going to work in your guy's favor.
Oh, yeah, absolutely. I mean, and there was no way to deny the fact that he had participated and helped with the cleanup. I mean, our position was simply he was helping his sister. His sister was in a bind, and their family dynamics and values were not the type that said, hey, let's call the cops. They were, hey, let's protect each other and let's get out of here. So he went with that, and he was helping her as much as he possibly could. But that doesn't mean that he committed murder. Either murder or both murders.
So let's go to opening statement. I know you told us early on what the prosecution's theory was. Take us through their opening statement and your opening statement and how you dealt with the things they brought up in their opening in your opening.
They kept it fairly clean in their opening, which is kind of the idea. That's why we call it opening statements. I mean, they're not supposed to be arguments. They're just telling you, we're going to present evidence of this. We're going to present evidence of this. They're not connecting those dots for you like we do an argument. So they kept it pretty clean by staying with Christie's perspective on things that she had witnessed the murders. She had witnessed her brother do both murders, and that she had then been held captive, and then she sought help as soon as she could. I did what a lot of defense attorneys do. And I actually reserved opening statements. So that means that I didn't make an opening statement. I decided to wait until it was my time to present evidence. And at that point, based on whatever they had presented, I would decide if I was going to present an opening statement or just waive it still and go on into evidence.
Interject here because that strategy is extremely rare. What'd you call it?
Scary?
Scary, rare. We almost always feel the need to give an opening statement immediately after the prosecution gives its opening statement. So
or to leave it open like that and let them listen to the prosecution with no comeback.
So there had to be some strategic reason as to why you did that, and I would love to hear it now.
You know, a lot of it, I would say in these more serious cases, murders, sex crimes, things like that, you're more likely to have opening statements from the defense. However, there can be so many nuances and unexpected turns during a prosecution's case and what is actually presented on the stand or what is actually said, particularly when you have very limited physical evidence, that if the prosecution's case is going to be based a lot on testimony instead of physical evidence, you're more likely to waive an opening and let that play out and see what happens so they don't unnecessarily commit to something that ends up not even coming out on the stand.
Now that you've explained it to me, I'm more open to the idea of one day reserving my opening until I put on my case in chief.
It's always been my theory on sex cases in particular to waive opening because they're so testimony based and there's hardly ever evidence in a sex case. So waiving opening allows you to keep the options available and maybe at the last minute changing your strategy.
Before you put on your evidence, you actually did an opening statement?
I don't think I did. I think I waived it. Oh, it was a lot in 2 weeks. It was a lot.
It was a complete waiver. You didn't even reserve. Well, you probably reserved it and waived it at the appropriate time.
Yeah. And in fact, I'm almost certain I did because I had prepared one and kind of had an idea going through the prosecution's case. And I really tried to pay attention. I'm not very good at paying attention to the jurors because I don't want to be caught staring at them during any portion of the trial because it makes them self-conscious and they stop reacting. So that is one of my investigator's jobs. I mean, her primary jobs actually during jury trial is to observe the jurors and see what's resonating with them and then provide me that feedback as much as she can during trial. So she's constantly messaging me during trial. And the jurors were really nodding along with me. Whenever I would ask questions, I seemed to be picking up on points that they were questioning as well. And they were frowning a lot and looking very skeptical during the prosecution's case. So she's like, hey, you're okay. They're on board with you right now. So we might want to let that go and just move. So we tried to be very efficient and knock out our defense witnesses. I think our defense witnesses were very strategically selected and were very powerful. And we really timed them and scheduled them very, very well for how the testimony came out. There were some that were unexpected statements that really played well when the first witness said, it occurred this way. And Christy Baker comes up right after them and completely contradicts them on that point. That doesn't help her at all. Like, she had no reason to lie about it.
Let's go through some of their key witnesses, what they said on direct exam, and how you dealt with some of the state's key witnesses on cross-examination.
So this was certainly a case of too many hens in the hen house. A lot of hands were pulled in order to do this investigation. And you would expect a lot of hands to be pulled in to do this kind of investigation. You have 2 murders going on, and you have 2 different, I say crime scenes. Obviously, one was the crime scene, but you also have the hotel. So you have 2 different locations that have to be searched. And then on top of that, you have Christy driving a vehicle that is also searched. So you can call that a third scene that has to be searched. And they had, I want to say, 6 or 7 different investigators, in addition to another couple of agencies involved. Since she reported to DPS, a DPS trooper on the side of the road, they were involved. DPS took her to Lampasas County Sheriff's Office, which is a completely separate county, not involved in this case. So they could have been involved as witnesses. Copper's Cove is where the hotel was, the third hotel. So they were involved, and they went and detained my client. And then the murder actually occurred in Harker Heights. So you have 4 different agencies involved at this point. Our pieces include, our most concerning witness, if we had to go straight to that, was the lead investigator. Since the time of this investigation, the lead investigator had been terminated from Harker Heights PD, and for cause. As we later found out, he had pulled a taser on someone or something like that. And it was a complete violation of policy, obviously. And I don't know that there was so much of a credibility issue as there was just your judgment is clearly not totally on board with our policies. So it happened after this investigation occurred. So I didn't really want to focus on it or mess with it, but I did worry about him coming in with a chip on his shoulder, thinking that I was coming after him about his IA file. So I really tried to be delicate and respectful with him in particular. I approached him actually with my computer in hand, not even documents, but my computer, because I didn't print everything because goodness, there would be boxes and boxes and boxes of printed material. But we had a couple of questions. And since he was the lead investigator, everybody should have been coming to him, presenting the information to him, and having him put all of that information together and then issue new instructions for next steps. That wasn't really happening. And that was one of their problems in this investigation. They weren't communicating through one kind of leader. So when I was asking him questions about, there's no documentation about who Christy called when she found this glove and this jacket. So, and there really wasn't. We had searched the documents thoroughly, and there was nothing about who she called exactly. Where was she? How did she find them? Where did she find them? That stuff was not documented. So I brought up to him a report that was actually written by another investigator, but in theory, one that he should have reviewed while doing his investigation. So in theory, he should have been able to testify from it. As I approached him and had him look over it for a second, right off the cuff, he testified, "Oh, that's my affidavit." Now, I knew it wasn't his affidavit. But at that point, okay, if that's what you want to say, fine, whatever. I don't care to correct you on the stand and say, it's actually not. It's somebody else's report that somebody else wrote right now. That's fine. So I let him go with the fact that it was his affidavit, and he read through it real quickly, silently. And then I was able to ask him a few more questions about the jacket and the glove and notations that proved my point that there wasn't really any documentation about who called who and how this was discovered, which was a huge piece because the publisher did not miss that information or those two pieces of evidence in that hotel room. It didn't hurt me.
One thing I like that you did there that I think a lot of lawyers miss, or especially young lawyers. I mentor a few young lawyers. It would have been real easy in that moment to point out the fact that he didn't know his affidavit from somebody else's report. But what you instead chose to do was focus on the key points you were trying to make with the witness, which that all the things that were not done or done improperly or the things they didn't know. You didn't get sidetracked by something that didn't matter to you. Yep. Right.
He had not been a terribly harmful witness for us, so it didn't really serve my purposes to go and tear him down at all. I knew that he had walked in with that chip on his shoulder, and it wouldn't take much to really have him just devolve on the stand. And I didn't want to have that happen because that's the only point I needed from him was, you're in charge here. And they weren't feeding you all of the information. And ultimately, you did not include in your report how exactly this happened. And if you were really analyzing this properly, you would have made sure that that key information was in here because it is very, very important information. The other part that came from him that I really wasn't sure how he was going to answer this, during the interview with Christy, he had asked for consent to take her phone. And that's where the confusion begins. Did he formally analyze it with a cell phone dump, like plug it into the computer, do the download, the whole works? Or did he just flip through it real quick to see what was on it and decide it wasn't important and hand it back to her? Either way, she walked out of the agency on day one of this investigation with her phone in her hand, and we never saw it again. And that was a huge problem.
Well, so let's talk about that. What's the difference when you talk about, did he just flip through her cell phone or did he do a dump? So here's a scenario. If she's made phone calls and or sent text messages and deleted them, he wouldn't see that by just flipping through her phone, right?
Right. And she prefaced actually with, I've deleted some of the things on there.
And how would a cell phone dump? Would that stuff be recoverable in a cell phone dump?
Yes. The general rule is anything within 30 days is typically still recoverable. So that would have been incredibly helpful. I don't know what was deleted. I have no idea who all she messaged, what all she said, but it would have been really nice to know. I don't know if her GPS was turned on. I don't know if she was doing what I think she was doing, which is trying to access bank accounts and whatnot of Michael David's. I don't know. And it would be really nice to have that information. And that probably could have resolved this case a lot faster. My client would have not been in custody for that 5 full years.
That's so true. So the lead investigator is a problem, but you got a lot of good information from him. Who else do they call that? I know when they call the sister, what's her name? Christy? I know when they call Christy, she had to be their star witness. But before we get to her, is there anybody else the state called that you were concerned about? And if so, how did you handle that person, him or her, on cross-examination?
Ultimately, it was clear that there were 2 murders. We weren't fighting that fact. So the autopsies and things like that weren't going to be a problem for us. That was the only evidence that we objected to in the entire trial. There were a couple of pictures that were in there that we felt were just designed to inflame the jury. And so that was our argument to the court. Is we know there were murders. We're fine with the images that need to be presented in order for them to see that there were, in fact, bullet holes and whatnot. Okay, but we don't need to have some of these pictures. They're too excessive. And the court agreed. So I actually was able to be heard by the court, which was very welcoming for a defense attorney. We're not just sitting there as a potted plant being told no all the time. But we knew that there were going to be the autopsies, obviously. We knew there were going to be the forensics on the weapons that were brought in. We knew that they had not found the murder weapon. So even though Christy handed over a whole duffel bag full of firearms and firearm accessories, The murder weapon wasn't present. So we didn't really object to any of the firearms coming in. We didn't object to the booties that covered your feet when you're cleaning. Okay, those can come in. We all agree that my client was cleaning up. Our position is that Christy was too, but there was just a lot of that we didn't have a problem coming in because, okay, we all agree that happened. The question is who fired the weapon? So one of the investigators interviewed Christy Baker. Obviously, the lead investigator was present, but one investigator did the primary interviewing of her. So she was a little bit of a concern for us, but even then, we didn't really have much of a problem with her. I will commend all of the law enforcement officers who testified that when I would present something and say, well, shouldn't you have caught that? Shouldn't you have collected that? How could you have known that was not relevant? Shouldn't you have gotten it anyway? They agreed. They 100% fell on their sword and said, you know what? In hindsight, you're right. I should have done that. Sorry. Thank you. That's integrity. I mean, it was wonderful. The only issue that I really had actually during the trial with an investigator at all was not on the stand. After that person had gotten off the stand, we had subpoenaed financial records. And I'm not sure if you've had this experience, but subpoenaing a financial institution and asking them to get records to you and having those records to you within, I believe we had them in our hands within 24 hours is unheard of. We had subpoenaed records in hand 24 hours. We had a butt in the seat of the witness stand in 4 days. Unheard of. That is my investigator right there. She was diligent, very diligent. And she knew, she just had this gut instinct, which only experience in this industry can do for you. But she knew something crucial was in those records. And sure enough, it was. So we handed those records to the investigator that has taken over since that other lead investigator had been let go from the department. And we asked her if she would simply sit down, look through the records, and let us know if she had anything. We didn't care what it was. I kind of knew the only option here for what it could be, but we let her know anything that you want to say after you have reviewed these records. I will call you up and let you say it. I don't care what it is. I will call you up and let you say it if it changes anything for you. And this is the only time I was disappointed in the law enforcement during the trial aspect of it. She audibly reacted to some of the information in the statements, like, oh, with a lot of surprise, and then handed the records back to my investigator and walked out of the courtroom. And I was disappointed with that. It was me giving her an opportunity to do something right, and I was going to get the right answer into evidence anyway, so I didn't really need to deal with it. It just left me kind of disappointed with law enforcement, and I don't want to be disappointed with law enforcement. Quite frankly, our job as defense attorneys is a lot easier if you're really, really good at yours as law enforcement. I mean, I could still get paid then and have an easy job.
I had a trial about 2 weeks ago, and the officer on body cam was essentially guiding a witness statement like, oh, you should add this, don't add that. And on the stand, I got him to admit to doing those things. And he admitted to it being improper. He probably shouldn't have done it that way. And he said it was unfair to my client and it was unfair to the jury. And I essentially destroyed this guy on cross-examination, but the guy was truthful. He didn't try to evade the answers or lie. And he and I had a 30 to 45 minute conversation after court that day about life in general and what can we do to help these teens with all this violent crime that's going on. And I genuinely like the guy. I think he likes me too, but I gave him hell when he was on the witness stand. But I got nothing but respect for him because he did not lie. Now, there was another officer that I know was lying, and I went after him simply because he lied. He was the one that was upset with me, and he had a much smaller role. And I was just like, you know, if you don't have integrity, I'm not going to receive you well, and I'm not going to give you a pass. But the guy who had integrity, who was really crossed well by me, ended up being somebody who I legitimately respect and enjoy having a conversation with. So I get it.
It shocks me that I honestly had never had that happen. I have approached officers in the past and said, hey, look, I'm going to come after you. I'm going to come after you about this, hoping that you're going to simply acknowledge it. We'll move right on. And they will get up there and they would not acknowledge it. They dug their heels in. I had one where I took a screenshot of his dash cam. And you can clearly see the seatbelt that he pulled my guy over for not wearing. It's plain as day. Dug his heels in. That's not a seatbelt. That's the reflection on the back glass from the street light.
Okay.
Like, I'm familiar with the outline of a vehicle and the curvature of the back glass, and that curve goes the other way. That's not the reflection.
Yeah, and so are the jury. They're not random people who've never ridden in cars or ridden behind a car.
You can't ever look at them and say, I can never hear him testify. I can never see a police report with his name on it and not go, crap, we're going to have to take this into trial.
So let's deal with Christy. She tried to put her brother in the oven, which is a lifelong prison sentence.
Moment of remorse. Not one.
How did she do on direct? And then take us through how you dealt with her on cross.
To be honest, she was not happy with anybody. She was angry with the state. She was angry at being there. She was angry at everything. I will commend the state. You know, I had said early on they were helping in getting my computer and whatnot set up to accommodate all of the evidence that was coming. And they made sure every day before trial, the next day, they gave me a witness list so I could know who was coming the next day. So I could at least focus on those and not have to dive through all of it trying to figure out who in the world they might call. But on the stand, they actually pointed out that, you know, hey, when you got back to California and we were prepping for this trial, 6 months ago, and you got arrested, that was us, right? So they acknowledged that they had their own primary witness arrested. And she didn't really care for them before that. So it didn't really do any damage for them at that point. But she just was very sharp and aggressive with them and with us. And it didn't do her any favors. And then again, immaterial pieces of information that did not move her needle forward at all, she still lied about and was compelled to lie about it. She insisted, for example, on the first night that they were at, it's a Super 8 motel, and she insisted, if you go get the surveillance footage, he strangled me out in front of that hotel. Well, we had the surveillance footage. We watched every minute of it. There was no strangling, ever.
That's a lie.
Never even... And I thought about this, that maybe you walked off camera together while you were still outside of the hotel room. Not one time. He would walk around the corner and smoke a cigarette or whatever. And then she would walk around the corner separately after he had come back on camera. There was not one time that they were both off camera. And kudos to Super 8. This was the clearest, surveillance footage. So we could see everything that was happening. I'm like, why lie about that? Like, it's on camera that she didn't get strangled. So, little things like that added up. When I'm asking, okay, we women, we all do this, right? So I'm carrying my keys, right? I'm carrying my eyeglasses case, and then I want to carry my water bottle. We do the stack, the girl stack. She walks out of the hotel room one day, and this is one of the key points that we were making the whole time, is that these Rockstar energy drinks are being drank by somebody heavily involved in this. The Rockstar energy drinks are located in the bedroom where the fiance was murdered. The Rockstar energy drinks are located at the little table that somebody was sitting at in the garage next to the car. And there was a lot of activity in the garage because the police live and everything was all in the garage. The Rockstar energy drink was crumpled up on the floorboard of the vehicle that the bodies were in. The Rockstar energy drinks were on the bathroom counter next to the makeup. The Rockstar energy drink were in the driver's seat of Christie's car. And when she walked out of the hotel room, she was doing the girl thing with a Rockstar energy drink right here. And I just asked her, hey, what's that in your hand? I don't know. My investigator still comes in here every now and then in my office and pops the door open and is like, is that an encyclopedia? Because that's what I asked her. Like, well, is it an encyclopedia? What is it? I don't know. Okay, do you have any idea what it might be, ma'am? I don't know. Okay, we talked all about the Rockstars the whole trial. So everybody in the jury box, they knew she's carrying a Rockstar energy drink. It's the same color of all of the other ones, one flavor. It is what it is. And then every time you see anything that we know was associated with my client, it's a fountain drink every time, or a beer. So it was a key point for us. The Rockstar energy drinks are around all of the criminal activity, but she wouldn't acknowledge it. She didn't know that was our point either, but she wouldn't acknowledge it. It was just little things like that. And then when we put on our case and we reserved her because we didn't have the cell phone dumps whenever she had taken the stand the first time. So, and I made sure the court knew before we even started the day, like, hey, I'm not being a jerk. I have to reserve her. I cannot let her go until I've had a chance to review all the cell phone. They went ahead and, God bless, they let her go back to California over the weekend. I was so worried that she would not get back on the plane and come back because I knew I was going to end up calling her again or calling her during my case. She did. I don't know why she got on the plane, but she got on the plane and came back. Maybe she thought it was going better than it was. I don't know. My investigator had located and interviewed her older daughter.
Christy's older daughter.
There's another lie. I asked her how many children she had. She said 2. And I went, really? She said, yeah, I have 2. I was like, oh, you mean, I can't recall the names off the top of my head. I was like, you mean this one and this one aren't yours? You don't have 4? And she's like, oh, why would you lie about how many kids you have? How does that move this forward? We had located her, one of her daughters, Alyssa, and Alyssa had come and testified and had never been visible to Christy. So we had coordinated, hid her away in rooms and whatnot so that we could pass each other in hallways. I mean, it was a very agreed to effort by the prosecution too. They cooperated in this and kept Christy hidden away as well. And we had Alyssa go right before Christy. And she explained that Christy was, had told everybody that her son, Manny, the one who was present during the murders, didn't know anything about David being dead. So we're not going to talk about it, which there's no way that boy didn't know. But that's how she evaded anybody in California ever asking him about it. She talked about how Christy was carrying this handbag, and it was like 2 weeks after the murders. She's carrying this handbag around and had blood smeared on it. And she was just very indifferent whenever somebody pointed it out. And she's like, oh, yeah, that's David's.
That is so weird.
Yeah, and it's not incriminating in itself, but it's odd. Her reaction to it was very unusual. She's using David's card still to pay for things. And she was in a very chipper, happy mood when she was coming to California, never said anything about the murders having occurred, was talking to Alyssa en route to California, taking selfies, smiling, sending them to her. And it was weeks before anybody realized that murder happened. And then you bailed and you were present during all of it. You're kind of a key witness to it. It isn't like you left and it happened while you were gone. So all of that behavior was very unusual. She was also one of the phone calls that was made by Christy at the hotel while she was being held hostage. And Alyssa talked about how odd it was and that they did not have a good relationship in the slightest. And typically Christy just called her if she needed something, and that was it. And it was always very short. Now Christy was in California trying to flaunt money because she never had money. And all of a sudden she's flaunting money, offered to make a car payment for Alyssa, that kind of thing. Not material to the case, but we called Christy up next and Christy's like, oh, my daughter and I had a great relationship. Oh, is that why your daughter doesn't want you to know that she is even here? She is so upset about the idea that you might know she's testifying that she's begging us to hide her away and bring her in a back door somehow. Okay, that's a great relationship you got. We positioned those strategically for that reason, and it played beautifully. I didn't even really ask for the information from Christy. She kind of volunteered it as a secondary part of an answer for me. I was like, well, I'm gonna leave that alone. Bringing Christy back was crucial. We were able to point out a lot of independent little things, little tidbit things. Having Alyssa, I mean, God bless my investigator, Daniela Sawyer. Having Alyssa was wonderful. The jury was really impacted by that testimony, and then having Christy come right back and contradict it. But I'd say, if I had to pick the key witness for the defense, it was the USAA representative who brought the financial records and testified about the financial records for us.
Tell us about that.
Oh, it was beautiful. We accomplished it. We got her there with the records in 4 days. I mean, that was monumental in itself. But when you look through the records, you see where Michael David had multiple accounts, and they show all of the establishment of the accounts, who was on them, etc., along with a couple of the statements, and then any changes to the signature card for those accounts. Well, you see a joint account with Christy and Michael David. That's the one they operated from a lot of the time. And then you see on the day of the murder, David goes in and removes approximately half of the money and puts it into a solo account of his. And that, along with in the cell phone dump, you see him searching evict my ex just an hour or two before the murder. And she apparently saw that in his search history when she took his phone, because she took his phone from the murder scene. So she was very upset about that idea. She saw it beforehand, but she had access to it afterwards. And then you see in the phone records how she transfers money for the next 2 months. She is transferring money to Cash App. She's transferring money from every other one of his accounts that she has access to into this joint account, and then operating from the joint account mostly. And then you see the money from the solo account is accessed. It's like, well, how did you do that? The USAA had notice as of October 1st. I don't know how it was that quickly, but it was. But they had notice as of October 1st that he is deceased. And as the witness is on the stand, because I missed it in my first review, I mean, I didn't have much time to review them, so I missed it. I'm scrolling through the records, and I see that on October 21st, mind you, he is deceased on October 1st, according to USAA. On October 21st, Michael David signs to add Christy Baker to his solo account.
Huh.
Boy, the fact that they did not pull these records ahead of time, they started to, and then they served it improperly or something, and they just kind of quit on it, and it just infuriates me. But overall, she transferred $22,000 to her Cash App account. A couple of those transactions, we can see those Cash App payments went out to a specific individual that we absolutely know was a methamphetamine dealer. And that's the only reason he was ever paid cash or Cash App transactions was to purchase methamphetamines. And overall, in 2 months' time, he blew through $50,000. The whole time she is driving a car that he took a loan out with USAA. He drove it to California. USAA ultimately wrote off the loan, and she re-registered the vehicle for 2 more years under Michael David's name in California. So he got in a brand new car. And nobody pursued this, looked at it, nothing. That means that his Michael Davis children and his ex-wife, who was requiring child support, for example, he could have provided for his children even after his death. She took that from them. And without a care in the world, that's her money. She'll say it was her money because it was a joint account, but the reality is she didn't earn any of it. That was entirely him. They owned a cleaning company together. You would think during COVID, October of 2020, we're right in it. You would think a cleaning company would be doing really well. Not really doing anything, and the cleaning van was sitting outside. Guess what was never searched by law enforcement at all?
The cleaning van.
Dan.
Yes,
Serious? And the carpet shampooer was not collected. You would think that would have fingerprints all over it from being used on the carpet underneath where the fiance had been murdered. Not touched. None of the cleaning supplies were collected. A vacuum cleaner was collected. I'm like, well, guys, the carpet was soaking wet. Y'all commented on the footprints that stayed and squished water because the carpet was so saturated from being cleaned with a carpet cleaner, but you took the vacuum cleaner. Okay.
That is a lot of mistakes in an investigation.
It's too many hens in the hen house, and nobody was really digesting any of the information and making intelligent, analytical decisions about it. The very benefit of being an investigator is having that investigative experience and analyzing what comes in to see what the next steps should be and what the evidence is telling you. And nobody was assuming that position.
So tell me, this is kind of a sidetrack, but from the moment you get a case all the way through the verdict, what role does your investigator play?
One of the biggest things that they have done and developed this step, if you will, in the process is they do a discovery audit. It is phenomenal. Her husband's a former police officer and she is a former dispatcher. So they know what should be included in an investigation. They know everything that should be included in every type of investigation. If there is evidence that is referenced, they document it. And then later, if they come across it, they check it off their list. If it's a certain type of investigation, so a sex case, they know with a child involved, they know there's going to be a forensic interview. They know there's going to be a forensic diagram. They know their advocacy center records to some extent. And so they write those down immediately, like this should be here, should be here, should be here, should be here. And as soon as they come across it, they check it off. Whatever's not checked off at the end of the day gets put, they auto complete a form and we plug that into our motion to compel discovery after we've requested it properly and received it, of course. And then we immediately fire off a motion to compel discovery. And then we have a set timeline now. Hey, did y'all get it? I didn't get it either. Send it again and get a hearing date with the judge. I mean, we've gotten ready for trial and been a month out from trial and said, hey, we don't want to have to ask for a continuance, but we're also missing 140 pieces of evidence. So what's the plan? And when they provide the missing discovery, I cannot tell you. In fact, we should probably go through and calculate the percentages, but I can't tell you how many cases have been outright dismissed because of their discovery audits. So between their discovery audits and my timelines, that's my key. I kind of mentioned earlier how I did an investigation of my own into my own situation, trying to figure out who was in my accounts and doing stuff with my accounts. And I developed a timeline and really got creative about where can I find documentation of where I was, what IP address I was using, what service is going to give me that information. We got a pretty whole list of ways that we can document locations and times and whatnot, and we put them into a standard timeline format that we've got, or template that we've got. Between that audit and that timeline, we have an extraordinary amount of success in Casey.
I wish I could get my hands on that template.
I'd share it with you. I don't mind. It's my integrity. I'm not competing with my counterpart.
I always tell people, like, it's doing criminal defense. There should be nothing that's proprietary.
Right. I was so afraid coming out and being a solo that would be the thought process, because I'm an entrepreneur as well. So it kind of is, but it's really great. A lot of defense attorneys share information and work and help each other, and it's truly wonderful.
No, we have to. I mean, it's bad enough it's us against the state and us being our small team against essentially the state prosecutor's office, whatever police agencies investigated. And, we should be willing to share. So I always tell people anything I have, it's available to share.
That is our theory as well. I mean, we have preached it and preached it and preached it. Our local listserv, our defense bar here in McLennan County in particular, is phenomenal. We have a listserv that is active every day, and we've got some brilliant appellate minds who share their information on the regular, and we are grateful.
Cool, great deal. So we go through Christy you call her, it sounds like the state called her on direct, and then you recall her in your case after her daughter. Do we need to hear about any other witnesses, or should we go to closing argument?
She was kind of it. We had another witness that we were thinking about calling and then ended up not calling him. So we had 3 witnesses total for our entire defense case on a capital murder, which is also a little scary.
You are one brave cookie.
Normally it's a little more than that. But
no, everything. I mean, even the signing up, I don't know if I could have done it. And I'm sure that there was very few people who would say, okay, yeah, let's roll into this. On the day of trial, I learned that I'm going to be lead.
If my investigator had not been involved and confident and had a very thorough knowledge of the evidence so that she could really help me out in making connections, I would never, ever, because I would have been exposing myself and not helping. The only reason I could do it and help him was because of her.
I feel a little bit better.
Yeah. On the face, it looks very risky and inappropriate. I shouldn't have done it, but I did have her, and she was amazing.
You had a person who, had an intimate relationship with the case and the facts and the evidence. So, sometimes I always tell people it's not, am I prepared? It's do I have enough to be prepared? And essentially, you felt like you had enough with your investigator.
I will say, before we get too far, this was probably the best 2 weeks of being a lawyer and being able to be in trial in my career because of the judge. Yeah. I mean, I am very accustomed to very states-oriented judges and irritation at having to accommodate things for the defense, like in McLennan County in particular, where the insurance for prosecution can sit in a jury box and help the voir dire, but my investigator is not allowed in the well of the courtroom or the jury. I mean, that's pretty direct and in front of everybody's face as a little biased. But this judge was kind, respectful. He was incredibly respectful to my client when he was pro se. Spoke to him with a great deal of courtesy and respect, which I initially acknowledged before he ever even talked about letting me on the case. And I appreciated then. He genuinely heard arguments from both sides and genuinely considered the law only, not biases, not preferences. I didn't have to deal with tiptoeing around some judge's arbitrary preference on how to do something at all. Right. He just let me be a defense lawyer. It was wonderful. And I thanked him multiple times. I'm sure the verdict was certainly a cherry on top, but I did thank him privately a couple of times, actually, before the verdict even came in, because it was just truly the best 2 weeks of being able to be a defense attorney. Kudos to the judge and the law enforcement officers in your case. Yes, yes.
Closing, the state goes first. In some states, I know the defense goes first. I don't know if that's the case in Texas.
We're sandwiched in Texas. So state goes first, then we go, and the state gets to go again.
We got the same problem here in Louisiana.
Yeah, defendants don't like that at all. I don't either, but I'm not a fan myself, but they certainly voice their displeasure at that.
Yeah, everybody thinks it's unfair.
Mm-hmm.
I would tend to agree.
Oh, yeah. I didn't realize it at the time, but the gallery of the courtroom packed itself during the state's open close, and close. So during the state's open close, all of a sudden the gallery, a couple of people and a whole lot of people even standing around because there wasn't anywhere to sit. I didn't see them or anything, honestly. I was so focused on my argument that we were doing. It was great. We could go in there and the court reporter brought all of the evidence out so we could pick through it all before the jury came in and kind of organize our stuff. Both sides got to do the same thing. There were 350 pieces of evidence.
It's a lot.
Yeah. It was fun. She kept it pretty organized, so she knew. I was like, I'm looking for this. She's like, it's in that box, I think, close to the bottom. Okay, thanks. She did a great job and was very easy to work with. So I was able to get all my evidence that I wanted to use gathered up. We actually had my client help us do a diagram of the residence, and we admitted that into evidence at one point. I will say, going back to the case in chief for the state, we had a couple of documents that we wanted out of the cell phone dumps. They had a little bit that they wanted out of the cell phone dumps. We all agreed the cell phone dumps were fine. Nobody had any problems with the authenticity of the cell phone dumps. Our big argument was we just didn't do them until July or August of 2025. We agreed to bypass the witnesses for those and boredom of those and put our evidence together. And the state even acknowledged it, like, hey, we've got some of the defensive preferences here and ours. We're going to put them together. We're going to label it whatever. But it is both of our evidence in here. We agreed to admission of that. So I was able to pull the pieces that we wanted, including the diagram and some of its cell phone records. And they have a document viewer in this courtroom. So you lay your document up there and it projects it, just like a projector when we were kids in school. And we were able to go through every bit of it. And our key points in closing were where people were standing according to our diagram. So where everybody agreed that everybody was standing at the time of the murder of the fiance. and then what we believe was an oversight by the prosecution about the autopsy records. So in the autopsy records, you state the direction of travel of the bullet from the perspective of the victim. So from up to down will be, from my to my chin, for example, from front to back, and my face to my back. And then this is where we think they got it reversed. So we know the bullet went from, where does it? I'm trying to do it backwards on the camera and everything. So we know where Christy was standing. The trajectory of the bullets should have come from my left to my right. So we know that it was a very straight line from front to back and left to right. It was very minimal, but there was some left to right. And so it was left of his body towards the right of his body from front to back. But it all stayed on the left side of his spine and breastbone. I think they got it backwards when they read the report. And I think they were assuming it was his right to left or left to right when looking at him. And it would make sense that it was my client as the shooter if you're reading it backwards. But if you're reading it correctly, according to and I didn't even ask the medical examiner this question, they volunteered it, but I did clarify it in my cross. But they were very clear and reiterated it a couple of times that it is from the victim's perspective. And the jury really was nodding on that point. So I knew they were paying attention to that distinction. And so I made a point of saying, you all were all nodding. You all heard her say it 3 times between his 2 on direct and me cross-examining her. It is the victim's left to right, the only person that possibly could have shot the weapon based on everybody's agreement about where everybody was standing. That would be Christy.
Well, that was great. This entire defense, I literally commend you. I can tell you guys paid attention to detail. Like, you guys were very, very thorough in really addressing every piece of evidence and looking for the details, the information that's, below the surface. A lot of lawyers, especially younger ones, will just kind of look at a big overview without really diving into the nitty-gritty of every piece of evidence, every piece of testimony that's got to come in. And I can see where you guys did that, and I can see how that kind of drove the verdict to where it went.
Point that I forgot to make, actually, that was one of my favorite finds in the cell phone dumps. I pointed it out and I made a diagram, a map actually, and mapped out the direction of travel and presented it very clearly in testimony, but I forgot about it in closing, was that the victim couldn't have been really that mad at my client or vice versa, especially not so angry with each other that essentially the instant he walked in the door, he picks up a gun and shoots the fiance. Because if you watch the GPS that also the state didn't pick up on or pay attention to, if you watch David's GPS at the time that my client is being dropped off at TGI Fridays, David's GPS drives to Fridays and then comes back and spends an hour at some other location. So he drives all the way to Fridays and then comes back within a few minutes. So he clearly just dropped him off and comes back. And then about an hour later goes home.
Does your client testify?
No.
How did you get the diagram in that you say your client kind of helped you draw the diagram? So who did you get it in through?
Well, my client helped in the sense that we were talking about locations because they've changed in 5 years. So TGI Fridays, for example, doesn't exist anymore. And needed a little bit of reference from him just because I didn't have that personal knowledge. But then through law enforcement, I was able to get that same information. I just couldn't talk to them as easily beforehand. But we just pulled that same GPS that they all had. It was in their possession the whole time.
The whole 5 years.
Yeah. It was in the phone at first, and then they finally did the cell phone dump, and even then, nobody looked at it. Which just blows my mind, because we all know how valuable a cell phone is. It tells the whole story. I mean, how is it that after he is dead, and right after the GPS turns off on his cell phone, he gets a text about opening a new financial account?
That Christy, yeah. Christy.
Misty opened it. So, there was so much information that we were just trying to establish. I mean, it's what I do in every case. We were just trying to establish that timeline, and see what was done by each pivotal party at every minute of this process. And by doing that, we told the story of what really happened. And thankfully, law enforcement seems to, at first they weren't really interested, but thankfully they seem to have picked this up, and we have actually cooperated with them in further investigations that may someday lead to an arrest.
Of Christy, I'd imagine, because you're.
Imagine.
And in fact, no matter what they discover, your client cannot be retried because of what legal theory?
Res judicata.
People know it as double jeopardy. Yeah.
Essentially, all of the lesser included, which people don't always understand, like you can't come back and try him for one case where there were 2 murders, can't come back and do 1 murder. So that's another reason that we were really comfortable in going forward with talking openly about his role in the cleanup afterwards.
Because they had, if they wanted to charge him with something related to that, they could have charged him with that in addition to charging him with both of these murders.
And if they had even done that the Friday before trial, it would have been fine. They could have done that.
That's right. Don't you hate when they do that?
Yes. But they didn't. And so we actually figured out that the day of jury selection, and right when we were about to start jury selection. So it really did help with figuring out our theory and how we were going to play things.
After you close, I think you kind of took me through the closing, at least what you...
A little bit.
Or take me all the way through it. I want to hear it all.
So my biggest points in closing were certainly the positioning of everyone during the shooting and the autopsy reports. I mean, that was point number 1, hands down. Point number 2 was the financials. So we went through the financials pretty clearly, and we drew their attention to the exact pages because we had testimony about the pages that we were most concerned about. But we had the projector and we didn't utilize it necessarily during the testimony as much as we could have. So we really wanted to drive that home. What was the date of this offense? Alleged offense. It was this date. What is the date that this dead man signed for her to have access to all of his money? 3 weeks later. And then we had done spreadsheets that we put on the front of this packet of information from USAA. We had the USAA representative review those spreadsheets for their accuracy and verify them. So she spent about an hour confirming every single transaction and that none were duplicated. They were all accurate and that they added to the correct amounts, etc. So we were able to include those in our packet with her and go over. One spreadsheet was all of the Cash App transactions from the joint accounts and whatnot to Christy Baker's Cash App from the date of the offense forward. The other spreadsheet was all of the transactions out of the joint account that were like cash moving, not just a debit card transaction, but cash moving. And ultimately it was $50,000 something of transactions and 22, I believe, into her Cash App. So we really focused on how to bet and how that was obviously a motive. And the idea he moved that money the day that he was murdered. And the rest of the time that he spent on his phone, an hour before he died, he's not being stupid. He's not out there blowing money. He's not buying stupid things on video games. He was playing video games, yes. But he was not out there buying crap on video games and whatnot. He paid the light bill on the water bill. For he's still being the adult and taking care of everything and being responsible. And we repaid him for this by murdering him. The other big point that we brought up were the cell phone records showing the communication and the specific timeline of that communication and what we know from the testimony that came in between some of these texts. So there would be an ongoing text about their bickering and their fighting and whatnot. And he was even saying, I'm in the room. Come talk to me. So they were in the same house texting each other and fighting. And then he's like, stop doing it. Come in the room. I'm in the room. Come talk to me. That's the end of the text messages. But you see before that, there are breaks and you see the entire tone of the text messages change in those breaks. One of those breaks is fairly long. And that is when Christy Baker's on the phone with Jerry Baker, who's at TGI Fridays for I think it was 20 minutes. We believe that she is relaying to him everything that's going on. He transferred money. He's searching for how to evict my ex. This is, garbage, yada, yada, yada. No discussion or no testimony came out about anything in that conversation. It is just at some point, this information was relayed, and based on the time of documentation of other things, we know this is the only time it could have been relayed. So we know in that phone call, these things were said. We also know that there was about a 6-minute break where things are kind of calm in those text messages between Christy and David. And then there's a 6-minute break, and then she is just fuming. She's livid. And these are heated text messages. I'm leaving. She says that, you're just dumping me out like the trash. She found out about the eviction search right then. That's what happened. And he said, hey, I'm done. We're ending this. It's over. We need to make plans, and you need to get your stuff and at some point quickly get out. That was the change in tone. And it was just a few minutes later that he died.
Now that we have done closing, the state gets to do a rebuttal close, right? So I kind of want to know your client's attitude, demeanor, how he's feeling, both during the rebuttal close and as you guys are waiting for the verdict.
He took instruction very well. So when I told him, hey, it doesn't matter what you do, if you do anything, it is going to be given a meaning by the jury. So you can smile at something and it will immediately be interpreted. You have to assume the worst. It's going to be interpreted as a creepy, sadistic smile. If you look down and shake your head, it's going to be viewed as disrespect of whoever's testifying. You just have to assume that it is going to be given the worst meaning possible. And therefore, if you don't know what to do, look down at your tablet that I gave you, draw a picture for all I care, write your ABCs, but have your pen in your hand writing on that piece of paper so that people do not think that you're reacting to whatever is being said in that moment. They just think that you're writing, and that's it. And leave it like that. If you don't know what else to do, look at your paper, don't make any facial expressions, keep your hands down. That's it. He did a great job. He did not react to things. He very calmly and quietly pointed out logical inferences from evidence that was being presented. He had a very intelligent thought process about everything, and he could actually identify questions and whatnot and points that needed to be made. And the very 5 seconds later, here's the prosecutor asking the exact thing that he just wrote down for me to pay attention to. So he really knew what he was doing. He's a very intelligent individual. It's one of those situations where, but for the circumstances of your upbringing, wow, life would have been completely different for him. He was a very stoic person with little bits of communication here and there during any period of time that he's out in front of other people. Now, back when we were doing prep, sure, he'd get angry about things. He would be, I say loud, but he would raise his voice, not aggressively, ever. He was just a very soft-spoken individual in public. And then he would get excited whenever we were back in the room working and prepping for trial. But he was never aggressive at all. And he didn't really get emotional other than there were moments where he was like, come on, y'all, when we would find something else that law enforcement hadn't done. And so I found it really interesting. He sat there stoically during closings. In fact, the only time I ever saw any emotion from him was after the verdict was read and then during a follow-up interview with the Texas Ranger.
Tell me about once the verdict was read.
We waited 2.5 hours. That was it for our verdict to be read. And I think part of that was lunch. Like, we had just ordered and gotten our lunch, and I think I had literally a bite of it. It was about 2:00, I think, when they called us and said, hey, verdict. And we were just right there in the courtroom in a little workroom outside.
That's a quick verdict. 2.5 hours is quick.
Yeah. If I'd had a 2.5-hour verdict on, a sex case, for example, I would have called that a success because I kept him out for 2.5 hours, right? So I was a little worried because quick is not normally a good thing for us.
Not for the defendant.
Oh, I did tell him, hey, anything can happen. Don't read anything into anything. But obviously, in the back, my investigator and I were going, uh-oh. And you prep them anyway. Hey, we've got a great case. hey, you and I both know this should be a not guilty. You need to be prepared for the fact that it's going to be a guilty. It's a capital murder, and to get jurors to overcome that title alone is a very hard, no matter how much we know that we've grilled them during voir dire about following the law and not letting the fact that we're even here, the evidence, getting over that title is a hard hurdle. So just be prepared. You're going to prepare everything for appeal. That's our goal, is to get a good appeal. When I tell you my jaw dropped, I'm not exaggerating. I literally had to remind myself to close my mouth after a second. It was, oh my God, they listened. They heard us and they followed the law. And it's done. I heard his breath hitch a little bit and I saw his eyes water a little bit, and that was all we got.
That's beautiful. That's beautiful.
Yep. He was very happy. To look at him from afar, you'd never have known he'd heard anything. But I heard it and I saw it and I smiled and patted him on the back and said, we did it. And then we went back and he got changed out and we got to go into our little trial prep workroom that they had for us and have a few minutes of just happy debriefing. So it was a good day. It was a very good day.
It was a good 2 weeks.
It was a good 2 weeks. It was a fright, to be honest. I had not that much fun in trial ever.
Does that mean you're going to be signing up to be lead counsel on the first day of trial in the future?
No, I don't see this scenario playing out again ever in my career, and I would not recommend this scenario playing out for anybody. It just happened to be the perfect dynamic, the perfect setup with Daniela knowing everything about this case and knowing that she and I together could do it.
What would you say this case taught you? Because we take something from certainly every case we try, even a lot of the cases we handle. But going through this trial, what did Brittany learn?
Honestly, that I'm not crazy for being frustrated at times, a lot of times, with the lack of communication with the DA's office, whichever county I'm in. I'm not pointing out any particular DA's office at this point. That I'm also not crazy for being frustrated about my inability to do my job in a courtroom. When I can do my job, and when I do have a DA's office who is acting with integrity, and I don't know anything, I know nothing about that office. Let me be very clear. I have been told things. All I know is the two ADAs that I worked with in particular, Fred Burns and Carson Walker, above board. They were honest. I could trust in the things that they said. They were genuinely interested in having a trial that did not come back on dumb things on appeal. Like, hey, I signed on the day of voir dire and jury selection. Obviously, the first thing that's going to come up is ineffective assistance of counsel because I don't know jack about this case or what's going on. And I signed up and I tried it. And then I lost. Surprise. So they made sure that they were doing everything that they could to ensure that this case went exactly as it should, that it was done without appealable issues. And in order to do that, it meant, frankly, guiding me through their witnesses for the next day, making sure I had every bit of evidence, making sure my computer worked and would open whatever it was. And I had all the drivers that I needed to open those specific programs, and they made it happen. So when those things are done and people are genuinely interested in getting a case for the true result and not the gamesmanship of it, justice can happen. Now that they know more about the rest of the story, and we've continued to work together in further investigations, I think that they are confident that the right result was reached. I won't speak for them, but I get that impression. We talked a little bit about kind of theories and what each of us thought had taken place, not just based on the evidence, but, just based on experience in these kinds of cases in the past and our experience in criminal law in general. And it was interesting to see the perspectives from, at least from one of them that participated with the after trial interviews, and for them, and to be able to share with them what I did know and what I suspected and what I could share with them. Because obviously it's still, some aspects of that are confidential, but we were participating in interviews as well. So a whole lot was being discussed with permission to do so. He has helped them at least get on the right path to hopefully finding the murder weapon, my client, Yep. And they do have a fresh Texas Ranger investigating it now and kind of taking point on that. So it's going to be a completely fresh set of eyes. And he even brought us in for interviews and said, like, I am sure this came out in the trial, but I'm truly trying to look at this completely new, completely fresh. So bear with me. And sure, yeah, we talked a lot about things that absolutely came out in trial and we already knew and we've already been down this road, but he was genuinely interested in pursuing it and investigating it thoroughly and trying to find the right answer and see if it led to an arrest.
This was great. This was a great result. Sounds like for a great guy who, essentially got dragged into his sister's foolishness. And then she tried to pin it on him. There's going to be more. There's going to be more people out there who are going to need somebody like you, Brittany. So for the people in the areas you service, I know you say Waco. I guess would that be fair to say the Waco geographic region?
I'd say Central Texas.
Central Texas.
Yep. So, because I hit Johnson County and I hit all the way down to Bell and Williamson even. So
for the people out there in Central Texas that may need to find you, how would they go about doing it?
So my website is lannenlawpllc.com, or my phone number is 254-301-9195.
Look, I really appreciate you doing this. I'm telling you, this is one episode I feel like I need to rewatch just so I can reconsider if I'm questioning if I paid attention to detail this as much as I should, because it seems like you and your investigator really, really, really dove into the details of everything to really uncover the truth.
That is the goal in every one of our cases, because when this stuff was happening to me and we didn't know who was doing it, not this stuff, I wasn't murdered, but when somebody was accessing all of my information and disclosing it to individuals, and I knew it was happening, I could see that it was happening, but I couldn't figure out who it was. It made it that much more real to me that people could be charged with things. I mean, I was being blamed for things that I had no part in. I had no knowledge of what they were talking about. Not criminally blamed, but it became that much more personal and real to me that people could be charged with things and the proof could be there. Technology could have all of the answers and we just weren't looking. It's made me a better attorney, and I hope that, I know that it resulted in helping Mr. Baker, and I hope that it has helped other clients as well, or they feel that it has. I feel like it has gotten better results, certainly in some of the family law cases and whatnot, where I can prove where my client was or that my client didn't send a message or whatever the case may be. And we've had several great results in criminal cases as well. I don't know that we'll see another one of these again. We did look, and I believe there are 7 not guilties that we found in Texas history, and only about 4 of them are straight not guilties. The others were not guilty by reason of insanity or something along those lines, or they a lesser conviction, a lesser included conviction, but only I think 4 were straight not guilties.
In capital murder cases.
In capital murder cases, yes. Well, so
you are a small class, small elite class. Sweet. So thanks. Once again, I appreciate it. I do want you. It's 2 things you mentioned. I want to plagiarize them. The way you do your timeline.
Oh my gosh! If I forgot something that was really interesting, do you want to use it anyway?
Oh yeah, go ahead. I'm gonna say.
During the trial, it came out that after she left for California, she got into another relationship and got engaged in February of the following year, so like 6 months after this murder. Guess what happened to him?
Don't tell me. Do tell me.
Shot in the head in 2023.
Shot in the head?
Shot in the head. And the guy that they had charged with that murder pled the week that we were in trial here. They had one little reference to her, but that was it. And I was like, you really need to dig into that. And the more they were digging, I don't know that they ever connected it and said it really was her, but he was posting on Facebook in a Facebook Live responsibility for this murder. We weren't able to get that because we were in trial and it's a Facebook Live from 2023. So, I mean, it was frankly, probably gone. I didn't even dive into trying because it was so unrealistic to expect to be able to get it. But he had been on a Facebook Live just like the day before saying that she was responsible for this murder. And I was like, guys in California, you might want to dive a little deeper because I would be willing to bet that she is responsible ultimately for yours. I don't know what happened there. I didn't follow up on that, but they were stunned.
She's what they call a black widow.
Black widow. Manny's dad died of COVID just 6 weeks before, not even 6 weeks, 6 weeks before our guy died. So she had 3 in 3 years that died. Now, one was allegedly COVID, but she had 3 in 3 years. That's crazy.
And she didn't seem too torn up about it either.
Not in the slightest. Not in the slightest. Mm-mm. She's the victim.
Hopefully they figure out what to do with her before there's a new victim.
Right? I hope so. And poor Manny, I have no idea how that boy is going to come out of there healthy, but it is.
Probably not. He probably won't.
Probably not.
In all honesty. You know how that affects a child. Okay, great. Great. This is a pleasure, and I appreciate you doing this on a Friday morning. They led into a Friday afternoon.
No problem. Happy to do it.
All right, great. Thank you. Take care. I'll be in touch.
All right.
All righty. Bye-bye.
Bye-bye.